Thank you. Why don't we get this magic started here? Good morning or afternoon, everyone, depending on where you are right now. My name is Horacio Mendez, and I am the President and Chief Executive Officer of the Woodstock Institute, and we're celebrating 50 years of consumer financial protection research and advocacy in 2023. Mark your calendars for our birthday party on June 8th here in Chicago. Would love to have all of you here. I'm thrilled to host another one in our series of lunch and learns. We were calling these brown bag lunches, but then my staff told me nobody brings brown bag lunches to work anymore, so we should probably change the name. My choice was to call these the Situation Room and invite 8 people to yell over each other at the same time without really saying any substance. But I was told somebody beat me to that, so I was kind of disappointed. So we settled on lunch and learn instead, given the timing and our ambition to educate through honest dialogue. We've had a few of these so far, including one where we discuss the pros and cons of community benefits agreements, introductions of our latest research, and updates on our community development, our community lending fact book and online data portal. You can find those on our website if you're interested or have trouble sleeping at night. So we wanted to finish the year off with a bang, and I think we're over-delivering. Our policy team are in a celebrity death match with Illinois' pawn industry over their inclusion in the Predatory Loan Prevention Act's 36% rate cap on consumer loans here in Illinois. We've got the Mensa Club of our research team getting the 2021 Community Lending Fact Book ready for launch in just a few weeks. And just because we don't like to sleep much, we thought it'd be fun to touch the third rail of CRA politics and have an event where we debated the future of the Community Reinvestment Act and, more specifically, ideas about how race should, could, or shouldn't connect to it. I'm willing to bet that I'm not the only one that got my hopes up when the Federal Reserve published the following question in their advance notice of proposed rulemaking to start off the 99-question marathon on CRA. Let me just make sure everybody knows what that question is here. So, in considering how the CRA's history and purpose relate to the nation's current challenges, what modifications and approaches would strengthen the CRA regulatory implementation in addressing ongoing systemic inequity in credit access for minority individuals and communities? So, the simple act of asking this question kicked off a national discussion about race, the law, and banking. Throughout our industry, hopes ran high that the agencies were finally prepared to explicitly address race in the CRA and incorporate it into the examination process. But as an Argentine American and a huge fan of the beautiful game, be it soccer or football, depending on your level of annoyance, the old adage here truly applies that it's the hope that'll kill you. So it was heartbreaking, but not unexpected, that discussion about how to integrate race into the exam process went the way of Jimmy Hoffa, or more currently, Sam Bankman-Fried's fortune. It disappeared mysteriously and quickly. In this case, from the 678-page notice of proposed rulemaking that ruined all of our summer vacations. The furthest that the agencies went was to propose incorporating Home Mortgage Disclosure Act data and published performance evaluations, but without considering the findings of this data and the assessment of an institution's ratings. As the Federal Reserve Board's late great Glenn Loney used to say, it's better than a poke in the eye with a stick, but really not by that much. Before we formally kick things off, I want to set the appropriate context surrounding this evergreen controversy of ours. Section 804 of the Community Reinvestment Act states the following, and I'm going to try to share my screen again more smoothly this time. There we go. In connection with its examination of a financial institution, the appropriate federal financial supervisory agency shall assess the institution's record of meeting the credit needs of its entire community including low and moderate income neighborhoods. So, there are two schools of thought when choosing to interpret this statement. One school believes it to mean that the inclusion of low and moderate income neighborhoods excludes the assessment of any other factor associated with the credit needs of an entire community. Another school interprets it to mean that all aspects of the entire credit need of a community must be assessed, including but not limited to the income of the neighborhood. So joining us this morning or afternoon, depending if you're in the East Coast, to either clarify the issue, muddy it up, or just give us all an excuse to start drinking early, are Calvin Bradford and Warren Traiger, who will introduce themselves and give us some context regarding their expertise on this topic. After introductions, we'll be asking each of them to make an argument regarding the issue of race in CRA, followed by a short rebuttal, hopefully respectful and using family-friendly language, and then a short closing statement. Now, given the headiness of the topic, I'll be monitoring the chat to identify any important issues or questions that might fit into this debate, but there won't be enough time for a formal question and answers. So, Calvin, let's start with you. Who are you? What is the context for your expertise on this topic?
Thank you, Horacio. I've been fortunate enough in my life to have wonderful mentors who've made it possible for me to work with a wide range of community groups, bankers, lenders, federal and state regulators, civil rights lawyers, and attorneys over the past 50 years. I'm presently a member of the board of directors of the Woodstock Institute. I've worked in fair lending and community reinvestment since the time before there was a CRA. I was a member of the planning and research teams that created pre-CRA national conferences on redlining and reinvestment that helped shape the CRA. I worked with National People's Action, the main community-based group that drove movement for the HMDA and CRA to help create the HMDA CRA. I produced some of the initial research papers on redlining, lending discrimination, appraisal discrimination, reinvestment programs, state and local, with the Woodstock Institute and Northwestern Center for Urban Affairs. And we produced documents for state agencies as well as for HUD. I'm a core member of the Master of Urban Planning and Policy program that was created at the University of Illinois here in Chicago. And I was a senior fellow at the Hubert Humphrey Institute of Public Affairs at the University of Minnesota. I've worked on the development and evaluation of CRA programs with groups across the country. I've drafted challenges, including one where the Board of Governors of the Federal Reserve unanimously rejected an acquisition based on my work on a race discrimination case against the bank. I've testified several times before House and Senate committees on fair lending and community reinvestment. I worked on the first national lender testing program with the National Fair Housing Alliance. I've produced HMDA discrimination analyses for metropolitan areas all across the country over the past 30 years, using every form of the HMDA data as it's been changed. I provided the data analysis for the Atlanta Constitution Journal articles Color of Money by Bill Dedman in 1988, for which Bill received the Pulitzer Prize and which led to new disclosure amendments for HMDA. I provided fair lending training to state agencies, HUD, civil rights groups, fair housing groups, local community organizations, and also banking institutions. I provided expert witness services in over 40 cases related to lending and housing discrimination. More recently, I'm a co-author with Robert Swem, the leading expert on fair housing law, on a law article on using disparate impact theory in fair housing cases after the Inclusive Communities ruling that upheld that theory at the Supreme Court. Thank you.
Thank you, Calvin. Warren, your turn to introduce yourself and the context for your expertise on this topic.
Sure. Thank you, Horacio. Well, I don't go back quite as far as Calvin does, but I have been practicing in the CRA and fair lending space for over 30 years. I'm currently a senior counsel in the New York City office of Buckley, and I primarily advise banks on CRA and fair lending compliance. One point I want to make that I think is important is, my bread is buttered by the banks, but I think one of the things that makes me effective is, I have some cred, I think, on the regulatory side and also on the advocacy side. And during my practice, I've witnessed 2 near-death experiences for the CRA that I'm hopeful we can avoid, but I'm concerned that including a race-based compliance component, can actually threaten the CRA. So I want to just share one thing, couple things here. So there we go. Okay, so I mentioned the 2 near-death experiences. First is when, for the first time in 40 years, the Republicans took over Congress in the midterm election of 1994, which, as many of you know, is when the current regulations, the Clinton era CRA rules were under consideration. And, there was a school of thought that the regulators were overreaching with those regulations. And sure enough, when the GOP took over Congress, one of the first series of hearings was on the Community Reinvestment Act and whether it should be repealed or changed. And the administration was smart to back off some of the more controversial components, such as allowing the regulators to fine banks for not complying with the CRA and issue cease and desist orders. So I was fortunate enough to testify at those hearings, and I certainly don't take credit for saving CRA, but I think it was part of a process that helped do that. The second, more current, but still 12 or 14 years ago, had to do with the foreclosure crisis. And as many folks, at least those that go back to 2008 or so, remember, whose fault was the foreclosure crisis? Well, naturally, poor people. Okay, it was their fault for getting loans that they couldn't afford, and it was the CRA's fault for forcing banks to make imprudent loans, which drag down the entire economy. Well, it's garbage, of course. Even though it had some kind of ring of logic. So my firm, published a study which pretty clearly demonstrated that CRA lending, that is lending done by banks covered by the CRA in their assessment areas, was much more safe and sound than a lot of the loans issued by non-banks and others. This is a study I'm very proud of. As you can see from the list of entities that cited this study, it clearly not the industry, not just the industry, but some brand name advocacy groups. So I join this discussion today. I think sharing an overall objective of not undermining the CRA and not, threatening its existence, which, I'm going to argue, could happen, if the regulators add a race-based component to what I feel is a colorblind law that provides banking services, loans, and other services to lower income communities and people, whatever their race or ethnicity.
Thank you, Warren. And we'll be able to get into some of that detail in just a minute here. So Calvin, let's get into the meat of this issue. And we will start with you as we agreed. You believe that race not only should be included in the CRA, but already is. Explain why. Let's get you off of mute as well.
Okay, I am off of mute. Thank you. My presentation actually begins years before there was a CRA. 9 years before the CRA in 1968, Congress passed the Fair Housing Act. The text of the act created protected classes. Among others, they specifically included race, color, national origin. We use race here to include color, national origin, and ethnicity. The FHA protects against discrimination in real estate-related transactions. This includes, but isn't limited to, lending, marketing and advertising, underwriting, appraisal, the sale and purchase of loans, servicing loans, and the availability of related services and products. The prohibited practices include, but are not limited to, the denial of services and products, differences in the terms and conditions of services and products, disparate impacts in the provision of services and products, based on a person's protected class characteristics or the concentration of protected classes in an area, i.e. redlining. Section 3608D of the Fair Housing Act states, all executive departments and agencies shall administer their programs and activities in a manner affirmatively to further the purposes of this subchapter, i.e. the Fair Housing Act. This affirmative obligation clearly applies to the prudential regulatory agencies. In 1988, Congress inserted the redundant phrase in blue into this section of the Fair Housing Act, and it reads, including any federal agency having regulatory or supervisory authority over financial institutions. In case the regulators didn't understand that the section included them, the added phrase imposed an affirmative obligation on the prudential regulators to enforce the prohibitions against race discrimination in the Fair Housing Act twice in the same paragraph of the law. Executive Order 12892, issued in January 1994, as the regulators were developing the revised CRA regulations, repeats Section 3608 and adds this paragraph. As used in this order, the phrase programs and activities shall include programs and activities operated, administered, or undertaken by the federal government, grants, loans, contracts, insurance, guarantees, and federal supervision or exercise of regulatory responsibility, including regulatory or supervisory authority over financial institutions. Collectively, the Act and Executive Order impose an affirmative obligation on the prudential regulators to enforce the prohibitions of the Fair Housing Act 3 times. And this is not even to mention ECOA. Citations from the regulators' FFIEC interagency fair lending exam procedures include detailed assessments of discrimination. The section on examination procedures listed here covers a range of topics: disparate impact, credit scoring, marketing, redlining, differences in terms and conditions, as well as direct treatment. These procedures require the consideration of race or racial concentrations. The section on redlining, for example, includes the location and range of services of branches related to the concentrations of minority residents. The May 2022 CRA notice, which Horacio mentioned, a proposed rulemaking by the Fed, OCC, and FDIC, contains the following statements about their understanding of race and the CRA. The CRA was one of several federal laws enacted in the 1960s and 70s to address fairness and financial inclusion and access to housing and credit. In particular, the Equal Credit Opportunity Act and Fair Housing Act, these laws include a specific focus on discrimination on prohibited bases such as race, as the first one listed. Then they say, these fair lending laws provide the legal basis for prohibiting discrimination lending practices based on race and ethnicity. These are the statements of the regulators in relationship to the CRA. Other statements from the NPR also clearly link CRA to redlining and race discrimination. Congress enacted the CRA in 1977 primarily to address economic challenges, predominantly urban neighborhoods. Redlining occurred when banks refused outright to make loans or extend financial services in neighborhoods comprised largely of African American and other minority individuals, leading to discrimination in access to credit and lesser financial outcomes. Then the agencies say, the CRA invests the board, the FDIC, and the OCC with broad authority and responsibility for implementing the statute, which provides the agency with a crucial mechanism for addressing persistent systemic inequity in the financial market for low and moderate income and minority individuals and communities. Citations from the regulations, which were then adopted in 1995, include an assessment area may not reflect illegal discrimination as part of the examination process. Maybe more importantly, is this provision, the board's evaluation using the Federal Reserve Board example of the regulations. Evaluation of a bank's performance is adversely affected by evidence of discriminatory or other illegal practices that violate an applicable law, rule, or regulation, which includes, and the first thing they include, discrimination against applicants on a prohibited basis in violation, for example, of the Equal Credit Opportunity Act or the Fair Housing Act. Therefore, the regulators' obligations include the affirmative obligation to further the Fair Housing Act, the obligation to enforce the Equal Credit Opportunity Act, the use of regular Fair Lending Act examinations, the obligation to assess a bank's service area for discrimination, and the consideration of violations of Fair Housing Act and ACOA violations as the ultimate CRA exam and activity before assigning a rating. All of these obligations require the specific consideration of race. The obligations for the regulators to consider race predate the CRA in the FHA. They predate the CRA in ECOA. It's emphasized in the Fair Housing Act amendments of 1988, made crystal clear again in the Executive Order 12892, is implemented in the Fair Lending examination process, is incorporated into the CRA examination process. No act of Congress or the federal courts has eliminated the consideration of race by the agencies. In order to justify the exclusion of race from the affirmative obligation in the CRA, Congress would need to amend the Fair Housing Act, amend the Equal Credit Opportunity Act, prohibit the consideration in fair lending exams, and prohibit the consideration of race in the CRA regulations. Therefore, it seems to me that the consideration of race is an obligation for the regulators, and therefore they must take it into consideration in their evaluations and their ratings in the CRA because of the law and their implementing regulations. Thank you.
Okay, wow, Calvin, lots of information. Can you stop sharing your screen now? Oh, great, thank you. Let's turn things over. Warren, you certainly don't disagree that there's an important racial element to the CRA that should not be dismissed or ignored, but it was excluded for a reason. You're concerned that overtly connecting race to CRA may even be counterproductive. So tell us more.
Sure. Well, I don't disagree at all that the regulators can absolutely, consider race and ethnicity in their enforcement of the Fair Housing Act and Equal Credit Opportunity Act. And they do. I mean, those are the bases for, redlining actions. Often very effectively applied by the regulators. Where we disagree is with the CRA. And I don't understand, an argument that says, well, the FHA and ACOA mention race, and therefore, CRA, which doesn't mention race, should mention it. And I want to take a little closer look at both those laws. Okay, so here we have the Fair Housing Act, all over the place. Okay, you can't discriminate because of race. Okay, or you can't discriminate, because based on persons of a particular race. And the Fair Housing Act is replete with references to race and to discrimination, and that's what it makes illegal. And as Calvin mentioned, it's been amended over the years since 1968 to make it even more clear that this is the law that prohibits discrimination, in what we refer to as the, life cycle of a mortgage loan. Starting with the development of the product and the marketing, right through the way the loan is serviced and administered. Similarly, the Equal Credit Opportunity Act, which was passed 6 years later, and by the way, at that point only prohibited discrimination in non-mortgage loans based on sex and marital status. And then in 1976, a year before the CRA, Congress added race, color, religion, national origin, and age. And similar to the Fair Housing Act, the Equal Credit Opportunity Act talks about discrimination. You can't discriminate. This is illegal. This is prohibited. Right? So then a year after that, the Community Reinvestment Act was passed. And Horacio, identified these sections at the outset of the call. What does this law prohibit? Well, it doesn't really prohibit anything. What it does is it encourages banks to meet the credit needs of the local communities, including low and moderate income neighborhoods. There are no references to discrimination. There are no references to race or any protected class. The only exception, and I don't really view it as an exception, are amendments in the 1990s where Congress said that regulators could give consideration, credit for banks that supported minority and women-owned depository institutions. But you'll notice that Congress instructed the regulators to do this. It was not something that the regulators perhaps felt was authorized by the law without the specific authorization. So Calvin mentioned, citing a couple of instances in the existing CRA regulations that clearly, have to do with race. So two important things: that your assessment area, your community, can't reflect illegal discrimination, and no matter how good your traditional CRA performance, your rating can be undermined and reduced if there's other evidence of a illegal credit practice involving discrimination. And I'll be the first to say that they're pretty logical, those two requirements. I know the second one, goes back all the way to 1979, as the regulators were first trying to put together the CRA regulations, because the law itself, as we see, is pretty short. A court has deemed it amorphous. So it's up to the regulators to put some meat on the bones. However, we can't look at what the regulators did in adding, in putting together rules that touched on discrimination as a basis, as a justification for a race-based compliance component. And one of my concerns is that, should the regulators, do this, and I don't have any, insight into the debate over this, when the question was asked, why the regulators, walked away from it. I can say that in review of the comments, advocates were pushing, and there was a radio silence from the industry, not wanting to touch this third rail. But I think part of the concern may have been, well, what happens to these long-standing regulations if in this new regulatory revision, we add a very clear racial component. Okay, not only are we going to look at service to lower income people and communities, we're going to look specifically at service in minority areas. I can almost guarantee, this is not a threat, but just observing the industry, that that's going to draw a lawsuit from somebody and put into question what everybody accepts now, that assessment areas can't reflect the legal discrimination, and no matter how many community development loans you're making and how good your penetration in mortgage lending is for lower income communities, if you have an ACOA violation, if you have a Fair Housing Act evidence of discrimination there, you can't be an outstanding or a satisfactory bank. I'm concerned that the same lawsuit, which looks at the appropriateness of a race-based compliance component, will also could theoretically undermine what the regulators have already done. That's largely accepted, but it was never been challenged in court. So I think we're better off staying away from that third rail. I also, the reason, but it's not just legal. I mean, let's say I'm wrong. Let's say a court upholds some race-based compliance. Okay, what's the impact of that? So the Center for American Progress, well-regarded left-leaning, organization, did some polling, in the context of COVID. What did it find? Okay, so it found, bottom line is that if something is framed in terms of poverty or, the income of communities or people, that the public is much more willing to accept a law that favors, lower income people than a law that favors minorities. That's maybe sad. We may wish that that's not true, but in fact it is. And if you look, the center, asked the question, two ways. And in a racial framing sample, Blacks and Hispanics, are they more impacted by COVID? Okay, you got only 46% saying yes and 39% saying no. But in a poverty framework, a framework like CRA's, the margin is 55 to 29%. I'm very concerned that a regulatory effort that adds a special racial component to CRA will undermine the public support for the law that has somehow, managed to survive, 45 years, of ups and downs. in American politics. I suggest that we continue to use the FHA, the Fair Housing Act, and the Equal Credit Opportunity Act to address discrimination in lending, including redlining, and let the CRA be.
Okay, thank you, Warren. And if you can stop sharing, thank you, and I'll give Calvin a second to unmute. Warren, I think you and I were both at the conference that Walter Kluwer decided to call a colloquium. And in the panel where I spoke, the ever pernicious Ken Thomas was one of the first people with a microphone and raised one issue that hadn't occurred to me was his calling to the bankers, the 200 or 300 that were there, was if you don't like what the FFIEC puts out with the CRA, you can sue them the same way that some advocacy organizations sued the OCC with regard to their CRA proposal. And I think you're starting to see that tactic being much more seriously considered. So you raising that, I think the timing of it is something that we need to give thought to. Calvin, you have up to 5 minutes to respond to Warren, including asking any questions you might have.
Well, I begin first by looking at public opinion. I don't think we do civil rights laws in the United States based on public opinion polls. And as far as them not considering race, it just always reminds me of Martin Luther King's statements that all we have to do for racism to persist is for good people to do nothing. So it seems to me then that the Fair Housing Act, twice, as I've just shown, wanted to make sure the regulators knew they were supposed to use the assessment of race and discrimination in their administrative and oversight responsibilities. How you can suddenly exclude that from the CRA, but somehow it's okay to do in everything else you do, seems to me to be incredibly illogical. And then there's always the argument that, well, race isn't included in the CRA. And I want to go back and share my screen for a minute again. Come on, let's go share. I'm going to go down. I have several points, but I want to example, the text of the CRA does not include these terms: Fair Housing Act, Equal Credit Opportunity Act, Truth in Lending Act, Home Ownership Act, all of these laws. That's true. But it's also true that it doesn't include the term assessment area. It doesn't include lending test. It doesn't include investment test. It doesn't include service test. It doesn't include strategic plan. It doesn't include high satisfactory. It doesn't include low satisfactory. So the question is, are the regulators then prohibited from incorporating any of these in the CRA process because they aren't in the text of the law? In fact, they made up the nature of these tests, service tests, strategic plans, out of whole cloth, which they are supposed to do because section of the Fair Housing Act gives them the right to develop these regulations. So this notion that because something is not in the text of the law that it can't be in the enforcement, it seems to me to be totally absurd, because then all the things that are done in enforcing the Fair Housing Act, looking at lending tests, investment tests, service tests, strategic plans, high and low satisfactory, even the assessment area, couldn't be incorporated because they weren't specifically written by Congress into the law. So the question here is whether we're going to look at civil rights and look at redlining, which is a racial issue as well as an economic issue. There has to be both. It can't just be economic. And historically, of course, it's really been racial. The question is whether the enforcement of CRA, the regulators can decide to simply ignore something that they've been told twice by Congress not to ignore because it might be unpopular. Because it might threaten the act. Well, the act is always going to be threatened. It's been threatened over time by people over and over again. As the composition of the political makeup of Congress changes, these things are always threatened, just like the CFPB was threatened and has been threatened over time. Raising those questions as a reason not to enforce a Civil Rights Act seems to be doing the nothing that Martin Luther King warned us against doing. Thanks.
Okay, thank you, Calvin. If you could stop sharing your screen.
I will try and do that.
Okay, good luck. Oh, there, well done. Warren, your turn in responding to Calvin's position, including any questions you might have.
Sure. So we're not, not doing anything. Okay, we're using the Fair Housing Act and a COA to address discrimination. What those acts instruct the regulators to do have nothing to do with the CRA. You can't take authority in the Fair Housing Act and somehow say that that gives you authority in the CRA to bring in a racial component. I also disagree with the fact that, assessment area isn't mentioned in the CRA, somehow puts it in the same category as race. Okay, the Community Reinvestment Act, service to the community, that's just another name for assessment area. So that clearly is in the act. And if the regulators are going to assess how well your bank is serving its community, and particularly lower income communities, then it needs a mechanism to do it. So hence you have a service test and an investment test and a lending test and a wholesale test and all this other stuff that's out there. It ain't race, okay? The regulators can't just say, we're gonna include race because it's set forth in these other statutes. As I mentioned, Congress knew how to include race, in statutes. It did it with the Fair Housing Act. It did it, the Equal Credit Opportunity Act. It ultimately did it with HMDA, okay? But and the regulators need to follow those directions, okay? But there's nothing in the Community Reinvestment Act about race. What we find in the regulations, I'm concerned that those two could be tossed out. So Horacio mentioned, we're in a more of I used to always say banks don't sue their regulators. Well, that's just not true anymore. And I think it puts a lot, at risk in what I think is a very tenuous argument. And I want to share one quick thing here. And I don't think that the fight against discrimination should be controlled by what people think, at all. My only point is that it's going to undermine support for the law. Okay, and here's why. I think it runs, counter to the plain language of the statute, that that the CRA is purposely silent about it. And as I said before, legal challenge could threaten existing CRA rules. But even if race-based compliance was upheld, okay, an extra layer of enforcement based on the individual's race or the racial component of a census tract, I think would backfire in the court of public opinion, and giving the optics of emphasizing one group of lower income people over another. And I think would be foolish to ignore that and go full speed ahead. Okay. And then finally, it's really unclear that this is at all necessary. Okay. According to the Urban Institute, 73% of predominantly minority neighborhoods, that is, neighborhoods with at least 70% minority population, are also lower income communities. So we capture, most of this, most of lower income minority communities within the, framework of addressing all lower income communities. So I don't think it's necessary. I think we have the tools that we need to fight redlining. And, the CRA should be left alone.
All right, thank you, Warren. And I think we're well served to remember the current composition of the Supreme Court and some of the cases that they're taking a look at with regard to consideration of race. I know that the United States Department of Agriculture had made a very courageous decision to try to compensate for past behavior by providing capital at more affordable and accessible terms to Black farmers, only to have that in court almost immediately by all of the other farmers, and it being pretty resoundingly viewed as negative in terms of using race for those purposes through the allocation of government resources. So it is a touchy issue, and we are in a much more litigious environment than I think we've been in the past. So Calvin, with everything that you've heard, how would you like to close this lunch and learn? What are your closing thoughts?
Well, I guess I would say to begin with that I don't think the response overcomes the obligations that are in the law. It's typical in legislation that you don't write into a piece of legislation everything that the regulations have to do, because every law would then be several 100,000 pages long. That's what regulations are for. And it's also true that the other laws, fair housing law, ECOA, truth in lending laws, they already exist. And therefore, there is already an obligation in the regulatory process to enforce them. The notion that you have to reintroduce that and mention every one of those laws seems to me to make the regulatory process and the legislative process almost impossible in a practical matter. It also seems to me that if you just say, well, most of the people in low-income neighborhoods most Black people are already in low-income neighborhoods, we can just forget the other Black people, African-American people and Hispanic people and Asian people and Native Americans on the reservation because they don't happen to be in a low-income neighborhood, is a sort of way of saying, in the CRA, what we're saying is you can discriminate all you want. It should never affect your Community Reinvestment Act assessment. And if that's the case, and I'm sure it would be the case that if you put race into each of the assessment factors, somebody would sue. And it may be the case that the Supreme Court, the way it's comprised today, would in fact support that. But then you have to say to yourself, is it really worth having this Community Reinvestment Act that was intentionally created to stop racial discrimination? Is it a purpose of having it at all if you in fact don't deal with race? What have you really gained if you exclude race, other than, once again, denying people what has been the fundamental, most embarrassing part of the whole history of the United States, its history of race discrimination?
All right, thank you, Calvin. And I think you also have done some research that shows that enforcement of the Fair Housing Act and the Equal Credit Opportunity Act has much to be desired, and its impact on CRA has almost been overlooked in many cases. So if anyone's interested in that, I think that research is also on the Woodstock website. I think you found a little bit over 100 instances over the last couple of decades where there's been that disparity. So thank you for digging into that. I think maybe this issue wouldn't be as big of an issue if maybe ECOA and fair housing were actually implemented in a manner that made them work. But that's my editorial. So moving on to the last editorial, Warren, you have the last word.
Okay, thank you. I fully reject the notion that the CRA is somehow worthless without a racial component. We've seen trillions of dollars, pumped into lower income communities of all, demographic makeups. And I think the color blindness of the CRA is not a limitation. It's a strength of the CRA, and its focus on income rather than race is purposeful, productive, and in many ways brilliant. Without shortcoming minority urban neighborhoods in any way, the CRA allows lower income suburban, exurban, and rural communities to share in CRA's bounty. And this is because CRA is not a zero-sum game or some kind of a government program with a limited budget. At its core, the law seeks to ensure that a proportion of a bank's overall lending, investment, and services benefit lower income communities, and ensuring that non-income, lower income communities receive an appropriate share of their bank's activities does not diminish what urban banks can do for their communities. To the contrary, it makes every community stronger. Doesn't mean that we can't improve it. And of course, the pending regulatory effort is trying to get at, CRA deserts, places where, the CRA does not have the kind of impact that it can. Okay, but you can't just take race out of thin air and add it to the CRA without anything in the statute. And that's my concern. Thank you.
Thank you, Warren. It's always a gift when you get to listen to really smart and experienced people, moderated by somebody who doesn't fit that bill. But still, thank you so much. Let's all give Calvin and Warren a virtual thumbs up for their willingness to address this important and somewhat controversial issue. I'm sure there will be a lot more to say once the federal bank regulatory agencies come out with whatever next steps they plan on taking with regard to CRA. You can see why this issue is not easily resolved. There are people that really care about the communities that the financial industry is chartered to serve, like Warren and like Calvin. And if this were an easy issue to address, it would have been done so already. But we're lucky to have these two individuals on our side and working with us and willing to talk to us. And for everyone who joined us today, have a wonderful, safe, and relaxing holiday season. And we will all see you in 2023. Thank you and be well.